Hey guys, this is attorney Shawn, the Criminal Defense Law Center again with another quick tip. One thing I always see people do when they're facing felonies is they come in and they say, I want to run the prelim exam and get my case dismissed. And we find that to be a bad idea here at the Criminal Defense Law Center of West Michigan. Look, the burden of proof is very tiny when it comes to trying to get the case past the preliminary exam stage, okay? It's just the prosecutor just has to show that there's probable cause you might have committed the crime. That's it. They just have to show probable cause. And if you run the prelim exam and lose, prosecutors are less likely to want to make offers to negotiate later on because they feel you wasted their time by running the prelim exam. The prelim exam is a very basic procedure. People think it's this great big hearing that goes on in court. I mean, look, I watched a prelim exam last week in court, and it lasted all of about 10 minutes, and of course it got bound over, and now that person probably won't have as much negotiating power with the prosecutor because they wasted the prosecutor's time and ran the prelim exam. There are certain instances where you might want to run a prelim exam. One, if you're trying to preserve evidence because you think a witness might not show up to court, or two, if you think the case is so incredibly bad that you may win at the prelim exam and get the case tossed, but that is exceptionally unlikely to happen. Trust your attorney if they tell you not to run the prelim exam. You don't want to get the prosecutor ticked off and totally slam the door on getting the best possible deal through negotiation.